If anyone expect industrial expansion in the United States in the middle of the 19th century typified the rest, it was a building of the railroads. Railroad building in the United States began in earnest about the time that Andrew Jackson was elected president. The first railroads, that is, the systems for transportation, that combined the use of rails with the idea for a steam locomotive pulling cars on them, appeared in the United States about 1830. In England, Boston, Lowell, the Boston, Worcester, and the Boston, Providence all began operating during the 1930s. And about the same time, in New Jersey and the Camden and Amboy connected the Delaware River Valley to New York Harbor. In Maryland, the Baltimore and Ohio started to build west from Baltimore towards the Potomac Valley. In South Carolina, the Charleston and Hamburg Railroad connected those two cities. In the 18 years between 1830 and 1848, some 6,000 miles of track were laid. In the next 8 years, nearly 3 times that much, 17,000 miles were laid. During the 1850s, the 4 trunk lines that come to link the eastern seaboard with Chicago each laid tracks over or through the Appalachian barrier from the east coast to the flat lands of the Ohio Valley and the Great Lakes. The railroad then ultimately became the New York Central, run up the Hudson River Valley from New York to Albany, and then west along the road of the Erie Canal from Albany to Buffalo on Lake Erie. The Erie Railroad ran from Point on the Hudson River in New York City around New York's southern tier counties to Dunkirk in Lake Erie. The Pennsylvania Railroad laid track from Philadelphia to Pittsburgh, negotiating its way through the Allegheny Mountains by means of the famous horseshoe curve. Baltimore and Ohio tracks began in Baltimore, Maryland, to follow the Potomac Valley through Harper Ferry and on to Wheeling, both then in Virginia on the Ohio River by 1860. Through connections on each of these roads existed to Chicago. With the settlements of the upper Midwest or Iowa, Minnesota, and Wisconsin, it became virtually foredone that Chicago would be a great railroad center. One need only look at the map of the United States to see the 300 miles water barrier Lake Michigan created between these states and the Northwest to understand why Chicago, located it was, and the food for Lake Michigan would become a great transportation hub. The coming of the railroad had a dramatic effect on farmers' choice of transportation for the products. In 1850, there was not a mile of railroad in Chicago, but by 1850, there were 2,200 miles tracks coming to the city, and 100 trains departing and arriving each day. It was very likely the largest grain market in the world, and farmers in Ohio, Wisconsin, and Illinois who had previously shipped their grain to market by means of Mississippi River boats, the barge now found it cheaper to get their products to market by means of railroad transportation to Chicago or other lesser centers. By 1858, Chicago had explicit St. Louis as the center of the grain trade, with twice as much of that commodity being shipped through the former as through the latter. Beyond Chicago, the first railroad track reaches the Mississippi River in 1854 and Missouri River in 1859. But development beyond the Mississippi River to the Pacific coast was obviously going to require support from the national government because the extreme sparse settlement in most of the area through which a Pacific Railroad would go. The idea of such railroad had been first broached in the 1840s, but sectional rivalries between the North and the South over whether the road should have its terminus in New Orleans, Memphis, St. Louis, Chicago, or St. Paul prevented the Congress from settling on any one plan. One of James Buchanan's last acts before leaving the presidency was to veto a Pacific Railroad bill passed by both houses of Congress, and although Lincoln signed a similar bill 2 years later, it was not until 1869 and driving the Golden Spike and Promontory Point, Utah, that the railroad linking the Pacific coast with the rest of the nation became a reality. Even in 1865, there was only a little over 3,000 miles of railroad track west of Mississippi, as compared with 35,000 miles east of it. Obviously, all this trackage was not devoted to trunk lines, and not only sizable cities, but virtually every small town, and soon anxious to have its railroad connection. This was matter not merely for local pride, but of economic survival. The pride or ambitions of every community was a shining track and the lively whistle of a well-laden train, with an accompanying statistics of crops grown, mills built, values enhanced. What does the railroad do for farmers? Asked Athens, post in 1855. Before the railroad reached eastern Tennessee, it answered the three counties of Brandley, McMinn, and Monroe grew less than 25,000 bushels of wheat and sold it for less 15 cents a bushel. But the fall of 1855 found them growing 400,000 bushels and selling for $1. While many farmers had originally opposed the construction of railroads, for fear that their market for horses, hay, would be thereby ruined, the experience of farmers in the Tennessee counties was duplicated in other parts of the nation, and shows us how important it was for every locality to have a railroad connection. What had previously been a local, best regional market for farmers produce, was thereby converted into a national and even international market. In 1851, Massachusetts held a railroad jubilee attended by state, national, and foreign notables. Within 20 years, there had been completed in Massachusetts 7 main lines of railroad track covering 1,000 miles, and not a single town with a population of 5,000 was without railroad transportation. Obviously, the availability of railroad transportation made a tremendous difference on farmers in the great breadbasket areas of the upper Midwest, and demand for each hamlet for access to the road of the Iron Horse was heard throughout that part of the country as well as elsewhere. But as with most other great economic developments in our country's history, the satisfaction of this demand brought with it important, difficult legal questions. One of them was a situation that arose from the frequent practice of cities and counties borrowing money in order to pay a railroad company to extend the company's trackage into its area. As with most such enterprises, there were good, well-managed railroad companies and poorly managed railroad companies. There were legitimate entrepreneurs, but on the fringe was a host of speculators. When the counties or cities had second thoughts about the wisdom of the money advanced to the railroads, legal questions arose and worked their way into the Supreme Court of the United States in the era immediately after the Civil War. In the early stages of railroad building, some states either built railroads themselves or undertook to fund the building of railroads within the state. But the states were generally concerned with the location of the trunk lines and left it to cities and counties to worry about branch lines. The construction of this branch line became a major concern to many cities and counties. In 1856, the people of Mansfield, Ohio, applied to the Atlantic and Great Western for terms upon which the road would be extended through their town. The directors decreed the subscription of $100,000 for railroad stock, and the right of way and the station side the fair prices payable in stock. Money wants to the railroads in stock, would be the terms. The town accepted, and the road was built. If the Atlantic Great Western may seem greedy for this request, its avarice was mild compared to that of the Northern Pacific, which in 1880 responded to a request for an extension of the line into the city of Superior, Wisconsin, by requesting that the town give the railroad 1/3 of the lands, promises, and the real estate in the city. This offer, too, was accepted. Agreements such as this were duplicated throughout the nation, and in state after state, millions of dollars were put up by counties, cities, and even small towns to induce the railroads to run their lines in a particular way. Many of the arrangements undoubtedly proved beneficial to all concerned, but human nature being what it is, there was bound to be discontent on the part of local taxpayers. Found their property tax bills increased for many years. All the railroad line had been completed in order to pay off the local bonds that has been issued to raise money to build the railroads. Generally speaking, if the private corporation issued a bond for which a purchaser paid good money, there is little or no doubt that the corporation is liable to the purchaser, even though there may have been some minor defects in complying with the corporation's articles or bylaws in deciding to authorize the issuance of the bonds. But the law has traditionally been different in the case of municipal corporations such as counties and cities, which are viewed as mere creatures of the state and their powers limited to such as may be allowed by the Constitution and laws of the state in which they are located. Because of this difference, purchasers of bonds issued by municipal corporations usually take pains to assure themselves that the city or county issuing the bond is authorized by law to do so. So it was in 1857, when the city of Dubuque, Iowa, undertook to issue $250,000 worth of city bonds to help with the construction of the Dubuque, St. Peter, and St. Paul Railroad Company. The people of Dubec voted favorably in the referendum to the issuance of the bonds, and our legislature passed a special act authorizing Dubec to issue these particular bonds and to levy a special tax to meet the principal and interest of the bonds if such was required. Bonds was issued on July the 1st, 1857. The principal payable in 20 years to an agent in New York at interest payable semi-annually. Whether because the effects of the panic of 1857, the failure of the railroad to measure up to expectations, or whatever, the city defaulted upon its bonds. The decisions of the Supreme Court of Iowa at the time the bonds were issued had held that there was no prohibition against their insurance in the Iowa Constitution, but after the bonds were issued, the Supreme Court of Iowa overruled this case and held that a particular provision for the Iowa Constitution made the insurance invalid, even though the city council, the people, and the legislature had authorized their insurance. When Gilpack had given money for the bonds and sued for the city in the federal district court in Iowa when it failed to pay the interest on the bonds when due. The federal district court and ultimately the Supreme Court of the United States were confronted with an intriguing legal problem. On the one hand, there was no doubt that the Gilpack had paid good money for the bonds, and no doubt that the lawyer minutely and meticulously examined the question in 1857, he would have concluded that the city was authorized by state statute and city ordinance to pledge its credit in this manner, and then there was nothing in the Iowa Constitution that forbade such a pledge of credit by the city. On the other hand, the question of the meaning of the Iowa Constitution is preeminently a question to be decided by the Supreme Court of Iowa and not by some other court. If that court concludes that the Iowa Constitution forbids the city to issue this sort of bond, logic would indicate that its view should prevail unless there is some provision in the federal Constitution that prohibits such a result. The Gilpack case was in the federal court only because of a diversity of citizenship. Gilpack was a citizen of a state other than Iowa, of which the city of Dubec was a citizen. And Congress in the Judiciary Act of 1789 had instructed the federal courts to apply state law when applicable to cases such as this. But the Supreme Court of the United States, obviously feeling considerable sympathy for the bondholders when it paid good money for the bonds issued by the city, refused to follow the decision of the Supreme Court of Iowa. The case was decided by U.S. Supreme Court in 1864 before any of the Civil War amendments went into effect. And the court did not see that the Iowa court had violated the federal constitution by reversing itself on the instead of a state law, but it nonetheless held for the bondholders. It undertook to interpret the Iowa Constitution for itself, decided that the early decisions of the Iowa Supreme Court, which had upheld the constitutionality for such bonds, were better reasoned than the more recent decision. In a concluding bit for rhetoric, Justice Swine's opinion said, "We shall never emulate truth, justice, and the law, because the state tribunal had erected the altar and decreed the sacrifice." Gilpack versus Dubec, 1864. Justice Field joined the majority in this case. Justice Miller disagreed with the rest of his colleagues, and in dissent he said, "The majority of the court has said to the federal court sitting in Iowa, You shall disregard the decision of the highest court of the state on this question, although you are sitting in the city of Iowa and administering her laws and construing her constitution. You shall not follow the latest, though it be the soundest exposition of its constitution by the Supreme Court of that state. But you shall decide directly to the contrary. And whereas that court has said that a statute is unconstitutional, you shall see that it is constitutional. When it says bonds are void, ensued in that state because they violate its constitution, you shall say they are valid because they do not violate the constitution. Thus, we are to have two courts, sitting within the same jurisdiction, deciding upon the same rights, arising out of the same statute, yet always arriving to the opposite results with no common arbiter of their differences. So the majority of the Supreme Court of the United States, without expressly holding dubious question, actions in repeating its bounds validity of the federal constitution, accomplished the same result by simply refusing to follow the decisions of Iowa courts when a case involving our law was brought in federal court because of a diversity of citizenship. Reflecting the temper of the times in 1860, the Supreme Court for Pennsylvania, in a case involving a similar fact situation, said, "We know the history of these municipal county bonds, how the legislature, yielding to popular incitements about the railroads, authorized their issue, how grand juries and county commissioners and city officers were molded to the purposes of speculators, how recklessly railroad officers abused the overwrought confidence of the public, and what burden debt and taxation have resulted to the people. Money, the security, was created and thrown upon the market by this paroxysm of the public mind. And the question is now, how shall the judicial mind regard it?" Diamond versus Lawrence County. At least so far as the Supreme Court of the United States was concerned, the judicial mind regarded the interests of bondholders who had invested their money in these securities as winning far more heavily in the scale of justice than the limitation state constitutions place on the powers of cities and counties to donate money to the railroads. In the U.S. Supreme Court, when a common law court with the general authority to lay down rules of law that best served its concept of justice in the cases coming before it, a decision such as that in Gelbach versus Dubeck would be entirely defensible. Not only were bondholders totally unaware of any defect in the power of the city to issue its bond, but if each bondholder had employed a competent attorney at the time of his purchase and had requested opinion as to the authority of the city of Dubeck to issue the bonds, surely the attorney would have concluded that there was virtually no question but that the state constitution did not prohibit their insurance, and that the state law had by its express terms authorized their insurance. The later decisions of the court, our overruling early decisions, smack a good deal of trying to get cities and counties which had improvidently pledged money to induce the railroads to construct lines to them off the hook. But viewed in the perspective of the American constitutional system, where the Supreme Court has no generalized mandate to do justice, but is simply required to decide whether lawsuits dependent on state law with any federal constitutional question, the answer must be considerably different. Say, as restricted by the United States Constitution, the states are themselves sovereign entities with their own systems of laws and courts, and the Supreme Court, the state is considerably the final authority in construing the meaning of its own constitution and laws. The decision of the Supreme Court of Orleans earlier cases may have been improvident and ill-considered in the extreme, but these facts alone did not warrant the Supreme Court of the United States simply sending the Iowa decision and not. The court relies on the accidental presence of diversity jurisdiction as grounds for disregarding the decision of the Supreme Court of Iowa, and really had no better reason for doing it than it saw decisions were unfair to bondholder who had invested their money in reliance on the validity of the bonds. The railroad bond cases were very much a staple of the court's business during the 1860s and 1870s. But like so many other legal questions, and all but disappeared by the latter part of the 19th century, but the protein effects of the railroads to link all but the smallest village and hamlet to the giant railroad grid soon produced popular reaction in many states, which led to another and more far-reaching problem for the Supreme Court. Railroads in the United States were organized in the cooperative form and were capitalized through the sale of stock to largely private investors. Sometimes units of government bought stock, other times they may have contributed money or land to aid in the building of the railroad. But none of this changed the essentially private nature of the typical railroad corporation. The directors and the stockholders of those corporations and these first regarded the operation of the railroad from Philadelphia to Pittsburgh as being little different from the operation of a general store in either of these two cities. Store owners bought or rented the land on which his store was located and paid his supplier for the goods that he in turn sold to his customers. The railroad paid for the right of way over which their track ran, bought the material necessary to construct the roads, hired the crews to build the lines, stations, and other necessary facilities. The Pennsylvania storekeeper could open store when he chose in the morning, close it when he chose in the evening, and charge whatever he wished for the goods he sold his customers. If the customers saw that it was not open and convenient hours of the day, that he charged too much for his goods, or that his goods were of an inferior quality, they would presumably take their business elsewhere. Well, I'm going to stop here and wait for the next time.